Good good morning. This is the final day of reading the complete pamphlet of the NAACP's Appeal to the World 1947 document that cost 50 cents but was that had so much valuable history in it, and it also detailed the condition of the black man in 1947 and the black woman in 1947 and the black child in 1947. It is necessary for our youth to be aware of this document. Let me finish chapter 5 and move into chapter 6 today. The federal government aids housing discrimination. The United States government, through the Federal Housing Administration, wields great influence in the field of private housing construction. The Federal Housing Administration underwrites loans for home financing, establishes building standards, and assist in the neighborhood and community planning and executing the latter function. The Federal Housing Administration has thrown its entire weight and prestige on the side of keeping the Negro bottled up in run-down, segregated neighborhoods. The Federal Housing Authority's underwriting manual describes the techniques to be used in determining whether mortgages are eligible for insurance under the National Housing Act. In rating mortgage risk, the manual lists protection from adverse influences as one of the features to be rated in order to determine the eligibility of a loan. Where little or no protection is provided from adverse influences, the valuer must not hesitate to reject to make a reject rating of this feature. Adverse influences including the prevention of the infiltration of business and industrial uses, lower class occupancy, and inharmonious racial groups. It observes that deed restrictions are apt to be more effective than zoning ordinances in providing protection against adverse influences because if a neighborhood is to retain stability, it is necessary that the properties shall continue to be occupied by the same social and racial class. Even greater emphasis is placed upon these considerations in the case of underdeveloped or sparsely developed areas. The valuator is warned that the deed restriction should include the following provisions: prohibition of the occupancy of properties except by the race for which they are intended. No person of any race other than the shall use or occupy any building or any lot, except that this covenant shall not prevent occupancy by domestic servants of a different race domiciled with an owner or tenant. Negro citizens are held virtual prisoners in substandard housing all over America today. There is no relief in sight. The 79th Congress has under consideration legislation to establish a long-range housing and urban redevelopment program. However, the Congress has wholly refused to include in the measure any provision to correct existing housing discriminations against colored persons. This bill did not pass and has been reintroduced into the 80th Congress, which shows no present inclination to incorporate into law provisions to ensure that colored Americans will participate equitably uh, and without discrimination, even in federally sponsored housing programs. Health. Uniform discrimination against the Negro by public and private health services makes adequate and proper medical care for the exception rather than the rule, even when he has the money to pay for it. The sickness and death rate of the Negro in the United States is much higher than that for white persons, and this is not due to any innate susceptibility on his part to any specific disease, but is a product of the low economic and social status in which he is kept. Proper medical care is usually beyond his reach. His limited financial means cannot provide nourishing food, rest, and clean, wholesome surroundings needed for prompt recovery. The Negro citizen suffers from all of the disabling illnesses which affect the general population, but those diseases most closely align with poverty and its non, and its concomitants of inadequate diet, industrial overstrain, overcrowded housing, poor sanitation, and ignorance that unduly ravage him. Thus, the tuberculosis mortality rate for Negroes is more than 3 times that for whites. Syphilis occurs 6 times more frequently in Negroes than in whites. Pneumonia twice as often. Hospitals. Even in the cases where the Negro is able to overcome economic difficulties and has sufficient money to pay for medical care, he is seriously handicapped in procuring proper medical service from the public as well as private institutions. There are approximately 110 Negro-owned or operated hospitals in the United States, of which about 25 are accredited. For the most part, these are small. The overwhelming majority of colored persons must seek care, therefore, from white institutions, which in the South and border states, if they admit Negroes at all, enforce a rigid pattern of segregation designed to isolate the Negro patient from all contact with white ones, and so far as possible from contact even with equipment used for white patients. Negro wards in both public and private institutions are usually inferior, overcrowded, poorly serviced by physicians and nurses, and often located in the basement. But in the rural areas and small towns in the South, where hospital facilities and the general population are especially meager, Negroes are usually excluded altogether except for emergency treatment in the case of an accident. Negroes have died before even first aid was denied them. Because first aid was denied them, although the number of hospital beds needed by a community will vary with the type and prevalence of disease. Modern medical authorities set 4 beds per 1,000 persons as a minimum requirement for reasonably care for the populace. Such indications of health facilities for Negroes is shown by the number of hospital beds available to them. In Mississippi, the Negro population in 1940 was 1,074,578, yet according to a study made by the Council on Medical Education in Hospitals, there were zero point 0.7 beds per 1,000 Negroes, as compared with 2.4 beds per 1,000 whites. After a careful survey of hospital facilities for Negroes throughout the United States, a responsible organization concluded that in some areas where the population is heavily Negro, there are as few as 75 beds set aside for over 1 million of this group. Physicians, dentists, and nurses. In 1940, there were 3,430 Negro physicians and surgeons, 1,611 dentists, and 7,192 trained nurses and student nurses in the United States. White physicians numbered 161,551. Stated in other terms, there was one physician for every 743 persons in the general population, as against one Negro physician for every 3,530 colored persons. These figures are significant in terms of the Negro health. The attitude of white physicians in the South towards the Negro patients is often one of indifference bordering on criminal neglect. At the same time, few Negroes in the medical profession practice in the South because of its rigid because of its rigid, obnoxious, and degrading practices. The stagnation of being shut off from the main currents of intellectual and professional contact, and the ever-present exposure to insults and the insecurity of life, limb, and property resulting from armed violence. It has been estimated that in certain sections of the Deep South there is only one Negro physician to 171 Negro residents. The great majority of Negroes must always, therefore, put their health or even lives into the hands of physicians belonging to the dominant race. Moreover, Negro physicians and nurses are usually denied staff and inpatient privileges in non-Negro hospitals in every section of the country. This means that when it becomes necessary for a Negro patient to be hospitalized, he is generally cut off from the sympathetic and understanding care of the family physician. Furthermore, the denial of staff privileges in hospitals to Negro physicians and nurses materially reduces their opportunity for training and specialization. Sickness and death. The maternal mortality rate per thousand live births is 3.2 for whites and 7.8 for Negroes. Stated in other terms, 2.5 times more Negro mothers die in childbirth than white mothers. Infant mortality, according to figures in the United States Bureau of Census in 1940, is 69% higher among Negroes than whites. The sin of neglect arose to harm America during the recent war when it sought to corral every able-bodied man between ages of 18 and 37 for service in the armed forces. For the United States as a whole, 47% of all Negro registrants in those age groups physically examined for induction were rejected as unfit as compared to 27% for whites. As the following table shows, in the South, where the poorest Negroes live and the health and education facilities are poorest, the percentage of rejections is considerably higher than in the North, where these services are better but grossly inadequate. And we talked about um, the percentage of Negro and white registrants rejected after physical examination into the induction of a military service. In the South, 49.3% of registrants, Negro registrants, were rejected, while 31.8% of whites were. And in the North, 39% of Negroes were rejected, 26.1% of whites were. And in 1947, the life expectancy for a Negro, for a male, was 55.93%, for a female was 58.46%, while a white male was 64.98%, and a white female was 68.93%. Now we will move into chapter 6, which is the final chapter of the book, the Charter of the United Nations, and its provisions for the human rights and the rights of minorities and decisions already taken under this charter. And this was written by Rayford Logan. Provisions in the International Agreement for the Protection of Human Rights or of Minorities are a relatively modern concept. For all practical purposes, the protection of minorities was first written into the international agreement in the Treaty of Berlin in 1878, which prescribed regulations for the protection of Jews in Romania, but not even the signatories insisted too strongly upon the strict enforcement of these provisions. Meanwhile, Russia, one of the signatories, and many other nations, including the United States, continued to treat minorities with little regard for the principles of equality and justice. The failure to protect by individual treaty the minority within a country undoubtedly made many humanitarians eager to have included in the provisions of the Covenant of the League of Nations that would guarantee the rights of minority. But the desire of the Jews in particular to have incorporated a clause in favor of religious equality would have made it difficult to exclude a clause proposed by the Japanese in favor of racial equality. The adamant opposition of some statesmen to this latter provision resulted in the inclusion of any clause in the covenant of the League of Nations recognizing human rights or the protection of minorities. But the situation in Central and Eastern Europe, which was such that some kind of protection for minorities there had to be devised, repeating the procedure of the Treaty of Romania of 1878, the victorious powers imposed treaties upon Poland, Czechoslovakia, Yugoslavia, Romania, Greece, Australia, Bulgaria, Hungary, and Turkey, which define the rights of the minorities. But these treaties took a new step in that they placed the guarantee of these rights under the supervision of the Council of the League of Nations. One cannot fail to be impressed by, number one, the contrast between the detailed definition of these rights in these minority treaties and the absence of such a definition in the covenant of the League of Nations. And number two, the obligation imposed upon small and defeated nations to protect their minorities and the failure or refusal of the large and victorious nations to accept these obligations for themselves. The enforcement of these provisions for the protection of minorities left much to be desired. But the Council of the League of Nations did take one step that should be kept in mind if the machinery of the protection of minorities is to be at the very minimum at least as extensive as that which existed after World War I. The Council of the League of Nations voted that any member of the Council could call to attention of the Council to any infraction or danger of infraction of the minority provisions. In addition, the Council adopted a resolution on October 22, 1920 that as follows: evidently this right does not in any way exclude the right of the minorities themselves or even the states not represented on the Council to call to the attention of the League of Nations to any infraction or danger of infraction. This right of petition to a principal organ of the international machinery for the maintenance of peace and security must be, at the very least, maintained. The determination of the drafters of the Charter of the United Nations to universalize the protection of human rights and of minorities, which have previously rested upon agreements with individual nations, is manifest from the language of the Charter and the frequency with which the language is repeated. The preamble states, "We, the people of the United Nations, determined to affirm or reaffirm faith and fundamental human rights and the dignity and worth of the human person and the equal rights of men and women and of nations large and small." Article 1, paragraph 3 employs language that has probably been more frequently quoted than any other expression from the Charter. It states that one of the purposes of the United Nations is to achieve international cooperation in solving international problems of an economic, social, cultural, humanitarian character, and in promoting and encouraging respect for the human rights and for the fundamental freedoms of all without distinction as to race, sex, language, or religion. This last ideal of respect for human rights and for the fundamental freedoms for all without distinction as to race, language, or religion is repeated in the identical words three times, namely in Article 13, paragraph 1b, Article 55, and Article 76c. Article 62, paragraph 2, uses the same language with the omission of the words without distinction as to race, sex, language, or religion, but with the inclusion clearly implied. Thus, the Charter in 6 different places reveals the concern of the drafters that there should be no mistaking that their determination to establish the ideal of equal treatment of all men and women is in all lands. Not only did the Charter, by contrast of the Covenant, contain the unequivocal statement just cited, but the Charter also contains the stipulation by which these ideals are to be achieved. The Charter did not leave it to individual nations to decide for themselves whether they accepted the obligation to protect human and minority rights by writing this obligation into a treaty. The Charter, moreover, established the agency by which this protection is to be implemented, namely the General Assembly. It should be noted that there is placed upon the General Assembly the obligation to initiate studies and make recommendations for the protection of Human Rights and Fundamental Freedoms for All. The Economic and Social Council may make or initiate studies and reports to the same end. This distinction is vital since it makes evident that the spokesman for minorities should be able to present petitions to the General Assembly regardless of actions taken by the Economic and Social Council of any of its subcommissions. Subsequent actions by the United Nations also revealed a desire to make effective at the earliest possible date the provisions in the Charter dealing with human and minority rights. The Economic and Social Council, in language almost identical with that of the Preparatory Commission, adopted a resolution as of February 16th and 18th, 1946, as follows. Section A. The Economic and Social Council, being charged under the Charter with the responsibility of promoting universal respect for and observance of human rights and fundamental freedoms for all without distinction to race, sex, language, or religion, and requiring advice and assistance to enable it to discharge its responsibility, establishes a commission on human rights. Number two, the work of the commission shall be directed towards submitting proposals, recommendations, and reports to the Council regarding A. The International Bill of Rights. B. The International Declaration or Convention of Civil Liberties, the status of women, freedom of information, and similar matters. C. The protection of minorities. D. The prevention of discrimination on grounds of sex, race, language, or religion. Number three, the Commission shall make studies and recommendations, provide information and other services at the request of the Economic and Social Council. Number four, the Commission may propose to the Council any changes in its terms and reference. Number five, the Commission may make recommendations to the Council concerning any subcommission which it considers should be established. Six, initially the Commission shall consist of a nucleus of 9 members appointed in their individual capacity for a term of office expiring on 31st March 1947. They are eligible for reappointment. In addition to exercising the functions enumerated in paragraph 2, 3, and 4, the Commission thus constituted shall make recommendations on the definitive composition of the Commission to the second session of the Council. Section B, the Economic and Social Council, considering that the Commission of Human Rights will require special advice on problems related to the status of women, establish a commission on the status of women. Number two, the commission shall report proposals, recommendations, and reports on the Commission of Human Rights regarding the status of women. The subcommission shall submit proposals to the Council through the Commission of Human Rights covering its terms and reference. Paragraph 4 of Section B is Malutus Mutunus, like paragraph 6 of Section A. The Economic and Social Council elaborated and redefined its machinery and procedures by a resolution adopted on June 21, 1946 as follows. Resolution adopted June 21, 1946. The Economic and Social Council, having considered the report of the Nuclear Commission of Human Rights of May 21, 1946, decides as follows. Functions. The function of the Commission on Human Rights shall be those set forth in the terms of reference of the Commission approved by the Economic and Social Council in its resolution of the 16th February 1946, with the addition to paragraph 2 of that resolution of a new subparagraph E as follows. Any other matters concerning human rights not covered by items A, B, C, or D. Number two, composition. The Commission of Human Rights shall consist of one representative from each of the 18 members of the United Nations selected by the Council. B, with a view by securing balanced representation in the various fields covered by the Commission, the Secretary General shall consult with the government so selected before representatives are finally nominated by these governments and confirmed by the Council. C, except for the initial period, the term for office shall be 3 years. For the initial period, one-third of the members shall serve for 4 years, a term of each member to be determined by lot. Number D, retiring members shall be eligible for re-election. E, in the event that a member of the commission is unable to serve for a full 3-year term, the vacancy thus arising shall be filled by a representative designated by the member government, subject to provisions of paragraph B above. Number 3, working groups of experts. The commission is authorized to call in ad hoc working groups of non-governmental experts in specialized fields of individual experts without further reference to the council, but with approval of the president of the council and the secretary general. Number 4, documentation. The secretary general is requested to make arrangements for A, the compilation, the compla- comp, the com- for compiling and the publication of a yearbook or on law and usage related to human rights, the first edition of which shall include all the declarations and bills on human rights now enforced in various companies. B, the collection and publication of information on the activities concerning the human rights of all organs of the United Nations. C, the collection and publication of information concerning human rights arising from the trial of war criminals, quislings, and traitors, in particular from the Nuremberg and Tokyo trials. D, the preparation and publication of a survey of the development of human rights. E, the collection and publication of plans and declarations on human rights by specialized agencies and non-governmental national and international organizations. Number 5, informational groups. Members of the United Nations are invited to consider the desirability of establishing informational groups or local human rights committees within their respective countries to collaborate with them in furthering the work of the Commission on Human Rights. Number 6, human rights and international treaties. Pending the adoption of an international Bill of Rights, the general principle shall be accepted that international treaties involving basic human rights, including to the fullest extent practical, treaties of peace, shall conform to the fundamental standards relative to such rights set forth in the Charter. Number 7, provisions for implementation. Considering that the purpose of the United Nations with regard to the promotion and observance of human rights as defined in the Charter of the United Nations can only be fulfilled if provisions are made for implementation of human rights and of an international Bill of Rights, the Council requests that the Commission on Human Rights to submit at an early date suggestion regarding the ways and means for effective implementation of human rights and fundamental freedoms, with a view to assisting the Economic and Social Council in working out arrangements for such implementation with other appropriate organs of the United Nations. number number 8, the subcommittee on freedom of information and of the press. The Commission of Human Rights is empowered to establish a subcommittee of freedom of information and of the press. B, the function of the subcommittee shall be, in the first instance, to examine what rights, obligations, and practices should be included in the concept of freedom of information and report to the Commission on Human Rights of any issues that may arise for such examination. Subcommission on Protection of Minorities. The Commission on Human Rights is empowered to establish a subcommission on the protection of minorities. B, unless the Commission otherwise decides, the function of the subcommission shall be, in the first instance, to examine what provisions should be adopted in the definition of the principles which are to be applied in the field of protection of minorities and to deal with the urgent problems in this field by making recommendations to the Commission. Number 10, Subcommission on the Prevention of Discrimination. A, the Commission of Human Rights is empowered to establish the Subcommission on the Prevention of the Discrimination on the grounds of race, sex, language, or religion. B, unless the Commission otherwise decides, the function of the subcommission shall be, in the first instance, to examine what provisions should be adopted in the definition of the principles which are applied in the field in the prevention of discrimination, and to deal with the urgent problems in this field by making recommendations to the Commission. The Economic and Social Council also adopted on June 21, 1946, resolutions creating a temporary social commission of 18 members and giving the Commission on the Status of Women the status of a full commission with a membership of 15. These resolutions demonstrate that there has been no relaxation in the desire to carry out the evident intent of the drafters of the Charter. The crux of the problem lies in the method of implementation. The major obstacle in the way of any effective uh, any effective excuse me the major obstacle in the way of any effective implementation of the evident intent of the drafters of the charter of the resolutions of the Economic and Social Council just cited in Article 2, Paragraph 7, which provide nothing contained in the present charter shall authorize the United Nations to intervene in matters which are all essentially within the domestic jurisdiction of any state or shall require the members to submit such matters to settlement under the present charter, unless the evident determination to protect human and minority rights is nullified by this paragraph. The expression matters much which are essentially within the domestic jurisdiction of any state must be liberally interpreted. Recent history has demonstrated that many questions which could be rigidly classified as matters which are essentially within the domestic jurisdiction of a nation fall within the scope of the purpose of the United Nations to maintain international peace and security. The treatment of the Jews in Germany was a cause of the Second World War. The treatment of the minorities in Poland and other Central and Eastern European countries is one of the principal causes of international friction today. The existence of a pro-fascist government in Spain is considered by many members of the United Nations as a threat to the international peace and security. Indians in Bombay and Calcutta have proclaimed a boycott and protest against the legislation against Indians in the Union of South Africa and in India. As a member of the United Nations is protesting against the treatment of Indians in the Union. One could multiply these instances in which questions that are apparently within the domestic jurisdiction of a nation that constitute a threat to the international peace and security. It is not surprising then that M.F. Delhos, the Belgian delegate to the first session of the Economic and Social Council, stated on January 23, 1946, if human rights are systematically denied or violated in one or another part of the world, there can be no doubt that such situations with which we are all only too well acquainted will, after more or less brief period of confusion and anarchy, lead again to war. We submit that the well-nigh universal violation of the principle of respect for human and fundamental freedoms for all without distinction as to race, sex, language, or religion, as far as Negroes are concerned, comes within that category of the situation outlined by M.F. Delahas. We believe, therefore, that the questions fall within the scope of the last clause of Article 2, Paragraph 7, which adds, but this principle shall not prejudice the application of the enforcement measures under Chapter 7. The first Article 39 of this chapter stipulates the Security Council shall determine the existence of any threat to the peace, breach of peace, or act of aggression and shall make recommendations or decide what measures shall be taken in accordance with Article 41 or 40 or 42 to maintain or restore international peace and security. Not only should Article 2, Paragraph 7 be interpreted in such a way to make it possible under the Charter, but the spokesman for minorities should have an opportunity to present to the General Assembly petitions on the behalf of those minorities in order to assure that the attention of the Security Council will be directed promptly to such threats to international peace and security. As pointed out in page 40, the Council of the League of Nations adopted on October 22nd, 1920, a resolution giving minorities the right to call to the attention of the League of Nations to any infraction or danger of infraction of the rights guaranteed by the minority treaties. The Council further voted on October 25th, 1920, that it was desirable that the President of the Council and two members appointed by him should proceed to consider any petition or communication addressed to the League of Nations with regard to an infraction or danger of infraction of the clauses for the protection of minorities. This inquiry should be held as soon as the petition or communication in question has been brought to the notice of the members of the Council. We urge that these petitions on the behalf of the minorities anywhere be received by the General Assembly, because all members of the United Nations have a right to speak in the General Assembly. The General Assembly has just voted that there will be discussion of the veto. By the same token, we urge that the General Assembly, the sounding board of the conscience of mankind, be given the fullest opportunity to discuss petitions on the behalf of minorities. The General Assembly, except insofar as it is limited by Article 12, could then make a recommendation to the Security Council, which in turn, according to the view presented above, could take action in cases where the violation of human or minority rights constitutes a threat to the international peace and security. We note further that the petitions may be addressed to the Trusteeship Council on the behalf of peoples in the trust territories. Under the covenant of the League of Nations, this right was not specifically stated, but the Council in January 1923 adopted procedures by which written petitions were receivable by the Permanent Mandates Commission. Article 87 of the Charter of the United Nations has formalized this right of petition by providing that the General Assembly, and under its authority the Trusteeship Council, in carrying out their function, may be accept petitions and examine them in consultation with the administering authority. Moreover, the rules of procedure drawn up by the Preparatory Commission for consideration by the Trusteeship Council make oral petitions possible. It is important to note that Article 87 clearly stipulates that the General Assembly as well as the Trusteeship Council may receive petitions on the behalf of peoples in the trust territories. It would be highly inconsistent, to say at the least, if petitions on behalf of people in independent nations could not be received by the General Assembly. After this manuscript was originally prepared, the General Assembly, during the second part of the first section, took action which, in the opinion of some observers, gives liberal interpretation to Article 2, Paragraph 7 of the Charter. Reference was made on page 91 of the discriminatory legislation passed by the Union of South Africa against Indians residing in the Union. The Indian delegation to the United Nations formally complained to the United Nations in June of 1946, and the issue was debated in the Sixth Legal Committee, which began its sessions on November 5, 1946. After considerable discussion, it adopted a resolution proposed by the Indian delegation and amended as followed by a joint proposal of the French and Mexican delegations. The General Assembly, having taken note of the application made by the government of India regarding the treatment of Indians in the Union of South Africa, and having considered the matter, number one, states that because of that treatment, friendly relations between the two member states have been impaired, and unless the satisfactory settlement is reached, these relations are likely to be further impaired. Number two, it is of the opinion that the treatment of the Indians is in the Union should be in conformity with the international obligations under the agreements concluded with the two governments and the relevant provisions in the Charter. Number three, therefore request the two governments to report at the next section of the General Assembly measures adopted to this effect, As was expected, Prime Minister John Smuts of the Union of South Africa protested that the incident case was a matter essentially within the domestic jurisdiction of the Union and therefore outside the competence of the United Nations. In support of the latter position, the delegates of the United States, the United Kingdom, and Sweden submitted a joint amendment to the original Indian motion in which the three nations recommended that a international court of justice be requested to give an advisory opinion as to whether the matter was essentially within the domestic jurisdiction of the Union. But the Sixth Committee adopted the French-Mexican Amendment by 24 votes to 19 with 6 abstentions. The General Assembly also adopted the French-Mexican Amendment by a vote of 32 in favor, 15 against with 7 abstentions. What now is the real significance of this section? Mr. Wellington Koo, Jr., member of the Legal Department, United Nations Secretariat, has written, of course, in his private capacity, has concluded, although legally speaking there are good grounds for referring the jurisdictional question to the International Court, the committee in making its decision was primarily concerned with those articles in the Charter relating to human rights and fundamental freedoms rather than giving an exact definition to the scope of Article 2, Paragraph 7. Notwithstanding this primary interest in the political aspects of the question, however, it would seem correct to say that the General Assembly has implicitly recognized that any act in violation of this principle Any act in violation of this principle be set forth in the Charter as a matter of concern to all members of the United Nations and falls within the competence of the General Assembly, irrespective of the nature of the origin of the situation. This conclusion would, in the opinion of this writer, be more valid if there had been no treaty between India and the Union of South Africa. Before determining the extent to which Article 2, Paragraph 7 will be liberally interpreted, it would be well to have the General Assembly take action on the violation of minority rights in which there is no violation of a treaty. It should be further noted that no decision was made as to whether to further the impairment of the relationship between India and the Union of South Africa warranted action under Article 39 of the Charter of the Charter as suggested on page 89. As this publication goes to press, the General Assembly is still attempting to compose the differences um, between India and the Union of South Africa. Pages 9. This is the end of the the NAACP appeal to the world, 1947. The NAACP appealed to the United Nations for redress for Americans of African descent for all of the oppressive conditions that they faced in the United States of America.